point number 3.
No, union really not a,
Huh?
well, not a necessary party. Bank guarantee has been in cash.
That's right, that's
It may
right.
not be.
They may not be affected by
They
the
will not-
legal issue.
They will not be affected by this deal.
All right.
May it please.
Lord, before your lordship speaks of the matter on the merit clause, there is one IA we had filed, IA 152125 of 2022. We filed it as an intervention application because then our section 11 was pending, which we were opposing. But that order has been passed, so we wish to withdraw this application.
Sorry, I didn't get you.
There is an intervention application.
Who are you?
Lord, I am the applicant in that application.
Correct.
Because we were opposing an appointment of arbitrator on the same principle because the instrument was not adequately stamped.
Correct.
However, the division bench has appointed the arbitrator, so.
You're withdrawing
as
that.
per- Yeah.
There is some other party actually.
Yes, Lord.
You're not a party in this.
Not the main party. I was intervening then when it was pending, but now appointment has happened. So I don't want
You're
to
not
pursue
parties
this.
to the suit from out of which the matter arises.
Not,
You're not parties to the
so I just wish to withdraw IA 152125.
IA Rana Council for the applicant. So take his name, rates that the applicant may be perfectly withdraw. The application seeking intervention for stop dismissal will come.
I'm grateful.
My lord, there is another IA 185816 of 2022, my lord. This is an application for intervention. And my lord, we also have matters pending on a similar issue, my lord, which will be impacted by the decision of this honorable court in this matter.
We'll hear you.
Yes, my lord, that's all that I wanted to say.
We can hear that, that's all. We'll get light from us. That's enough.
How many other applications?
Right.
I have one application which
We don't
is
have to-
IA 1996.
Dispose it of each other.
That's right.
We'll hear you in the course of the,
So great.
and provided necessary. Supposing you have what you have to say, that's entirely for you.
Mindful of that. We'll be mindful.
The same thing I seek in IA 199969. If at all there is anything we'll add, otherwise,
Absolutely.
grateful.
Go ahead.
May it please. No, it's your
So
lordship.
you're going to address us first, you are the Amicus.
My lord, I would request your lordships may hear me first because there are two judgments before my lords, my lord.
Yes.
I will, my lord, I've had a lot of thought about this. I've also talked to the appellant also, my lord. I may not agree, my lord, with some part of one judgment and some part of the other judgment also. So, my lord, let me put out the case. Some portions they may not have to respond at all. At least your lordships will get the full picture. I request if your lordships permit, let me, my lord, lay it out and then your lordships may decide
Can be.
that way. My lord. It will be.
I'm for the respondent number 1, my lord. After the amicus.
You're for respond number 1.
After the amicus completes, my lord.
That is, you filed a section 8 application.
Yes. Yes. After
It has
that,
been allowed by the High Court.
Right,
Yes.
right.
In the petition.
Yes.
Correct?
My lord, the matter arises out of a reference in the NN Global case.
Correct.
One paragraph of which is relevant, my lord. I'll read it out. My lord, but this matter has a little wider implication because the issue which is now arising before, my lord, this honorable court and various high courts is really mainly in the section 11 jurisdiction. Because what is happening, my lord, is that there are two opposing views. One view says that if somebody points out to you that a document or an instrument is insufficiently stamped or not at all stamped, you, the section 11 judge, have no choice but to impound and proceed. That's one view, my lord. I would say that's the Garwari view. The other view which has been propounded is that no, this may not be. So, my lord, this is one possibility. One possibility which, and this is the possibility, this is what is being done now by the Bombay High Court. They are following this. But the Delhi High Court, on the other hand, is appointing arbitrators and leaving this question.
Section 16.
In section 16. Two judgments of this honorable court, my lord, have appointed arbitrators pending this reference. There are other cases which are pending where the judges have adjourned the matter to await the reference.
Oh.
So, my lord, this is if I may say so, there's a khichdi, everybody is going their own way. So it is ultimately for your lordships, my lord, to lay down the law one way or the other, whichever, my lord, appeals ultimately to your lord. Now, my lord, that's the practical aspect of the matter, my lord. My lord, also, my lord, I have in this regard, we have filed 4 volumes of compilation for your lordship's kind consideration. Essentially, my lord, the first volume is of the reference judgments. There are 3 judgments which are referred to your to this court, my lord. One is Garwade, one is, my lord, NN Global, and because intervening between the two, there is Vidya Drolia, and certain paragraphs of Vidya Drolia have been doubted.
46, what is that?
Yes, those 3 judgments are from the first volume. My lord, the second volume, which we have filed, is in re the Stamp Act. Because your lordships will find that in all these judgments, the focus, my lord, because, sorry to say this, my lord, arbitration appears to be very glamorous. The focus appears only on the Arbitration Act and not much debate or not much disputation insofar as the Stamp Act is concerned. So, my lord, the Stamp Act I will place before the Arbitration Act to understand, my lord, whatever my limited understanding of the Stamp Act. Then, my lord, 1 volume is on the Arbitration Act and 1 volume is on the 2 reports of the one of the Law Commission, of the 246 Law Commission, and 1 high-level committee, Justice Sri Krishna, and 7 or 8 articles, my lord, which I have put in only to show that people have very disparate views and use very sometimes intemperate language also. But, my lord, there are points of view in those articles which go one way or the other. So, my lord, I have also tendered for your lordship's consideration just now, my lord, a note of submission. It's rather detailed. I'm sorry that it's so detailed. It's 40 pages because I have actually referred to paragraphs which are, my lord, to be considered and some quotations. It is only to obviate my lord, the necessity for lot of note taking. I have tried to, my lord, therefore it's a little long. So, my lord, the way the note is organized is this. It's really, my lord, in 4 parts. My lord, the first is what is the scope of the reference and what is the submission I will make for your lordship's consideration. That's a couple of pages. Then, my lord, the Stamp Act, then the Arbitration Act, and only then, my lord, the reference judgments. Because I don't want your lordships to be colored either way by the reference judgments. There are some problems, my lord, in both of them, at least so far as I see. I may be wrong. So, my lord, that is the way that
Absolutely.
I want to proceed, and of course, my lord, subject to whatever your lordships. So, my lord, the reference, there are 3 paragraphs in the reference order. If your lordship just sees the note, and please pick up, my lord, the reference volume. I've my lord, tendered 1 volume of the, volume 1, reference judgment.
Convenience volume 1.
Convenience 1. My lord, there are 3 paragraphs of NN Global which crystallize this particular reference. I'll show those 3 paragraphs. If your lordships first come to page 194, which is where NN Global starts, my lord.
Mr. Banerjee,
Yes.
one question. See, an arbitration agreement is really an agreement within an agreement.
Right, my lord.
So effectively, there are 2 agreements.
Right.
So for the stamping purpose, what would be the valuation of the arbitration agreement? Just
My lord, I can answer that, my lord. For the stamping purpose, my lord, it is not the agreement which is relevant, but it is the
Right.
instrument.
instrument.
It's the instrument. Now, my lord, an instrument may have more than 1 agreement. As
The
your lord.
line of cases are there that there are actually 2 agreements so far as
Yes, my lord.
arbitration is concerned.
Yes.
One is the main agreement.
And one is the arbitration agreement.
arbitration
No
agreement.
difficulty.
What would be the value?
How the value is fixed, my lord, under the Stamp Act, my lord, if there is such a situation where in one particular instrument, my lord, more than 1 agreement is there, or more than 1 subject matter is there, my lord, section 5 and 6 of the Stamp Act deal with that situation, and it is really the higher value, the value of the substantive agreement, which is taken as the value of the instrument. You know, there are methods in the Stamp Act, I will show you also, which resolve it. So, my lord, Stamp Act issue is slightly different and Arbitration Act issue is slightly different. And if we keep them separate, my lord, then of course, my lord, we can match them up. Because the valuation issue, my lord, can be seen really with the Stamp Act. And unfortunately, there seems to be an error in NN Global, my lord, on the Stamp Act, which I will also, my lord, highlight. So that
Will a document which is unstamped, will it be correct to describe it as unenforceable? Or will it be more correct to say that it is inadmissible in evidence?
My lord, I would go with the second and I will place those judgments, my lord. I will show that an unstamped document is a valid document. My lord, it is merely inadmissible in evidence. The underlying transaction is valid and my lord, it is not null and void. That seems to be the problem with the judgment in Garware. My lord, I will highlight that in the first quote. So it is valid, but it cannot be, my lord, admitted in evidence. And
But you are actually saying that the invalidity and inadmissibility, they are different.
yes, my lord, I am deeply obliged, my lord. That is really going to be my first point. There is, and because of that, my lord, in an 11.6a situation where the 11 judge only looks at existence, there is no impediment, my lord, to a point, and there is no loss to revenue, my lord. Because one, my lord, we have to balance both. You have to balance the speed of the arbitration. You want to appoint an arbitrator quickly, you want to proceed quickly. And you want to appoint the arbitrator and leave everything with him. On the other hand, Stamp Act is a fiscal statute. And you, at some purpose, being an organ of the state, also want to protect the revenue of the state. So the question is, do you protect the revenue of the state at the stage of Section 11, or do you leave it to the arbitrator, who is also empowered, my lord, under Section 35 to do the same job? So it is not somebody who is escaping, my lord, from the tax net. And there are some very interesting observations in some Stamp Act judgments that it is not a weapon to be used qua a recalcitrant litigant, but it is really for the benefit of the state. So, my lord, I will come to first the Stamp Act and then this, but I'll just show your lordship the reference. 3 paragraphs of the reference, because that is all that there is, my lord. My lord, the judgment in NN Global starts in this volume, my lord, at page 197. There are just 3 paragraphs which are relevant, my lord, for our purposes at this stage. This was, my lord, I'm not placing the judgment now. Please come to page 215, where the judgment starts, where the issues are, my lord, framed. That's where the judgment starts. And the 3 relevant paragraphs, my lord, in so far as this reference is concerned, are paragraphs 34 and 56 and 58, 56 to 58. My lordships, first see 34, which is at page 243. (243) says, and I just read it, we doubt the correctness of the view taken in paragraphs 146 and 147 of the 3-judge bench in Vidya Rolia. Consider it to appropriate. Refer the finding in para 22 and 29 of Garware, which has been affirmed in 146 and 147. So, my lord, 4 paragraphs have been highlighted. I will be focusing on these 4 paragraphs later, my lord. These are the 4 paragraphs that the 3-judge bench seems to have disagreed with. And I would say, my lord, correctly disagreed with these paragraphs. And then, my lord, the last page of the compilation at page 252, the last 3 or 4 paragraphs, and the question, my lords, is formulated at paragraph 58. Lordships, got paragraph 58? That's the last page. Whether the statutory bar contained in Section 35 of the Stamp Act 1899 applicable to instruments chargeable to stamp duty under Section 3 read with the schedule to the Act would also render the arbitration agreement contained in such an instrument, these words are a little problematic, which is not chargeable to payment of stamp duty, as being non-existent, unenforceable, or invalid pending payment of stamp. This is how the question has been formulated. Now, my lord, if your lordships are pleased to just look at the note which I have handed over. My lord, I've just read out these 3 paragraphs in page 1. And then, my lord, my submission, such as it is, which of course your lordships, I'm sure will not be acceptable to many on this side of the bar, but maybe some may accept this, no? So, in 6 or 7 points, I have tried to summarize my submission, which I will try and make good. Under section 11.6a, which is the section which your lordships will be looking at, the court appointing arbitrator shall, notwithstanding any judgment, decree or order of any court, confine to the examination of the existence of the arbitration agreement. Now, this is the statutory requirement, injunction and interdict.
By information 6A, section 11.
6A, my lord, has been deleted.
Not notified.
But not notified.
So, my lord, examine the effect even after decision.
Yes.
A is a different context.
6.
It leaves no room for discretion to examine, judicial discretion.
My lord, after
When the application is filed, you have no option but
my lord,
the agreement contains the clause of arbitration, appointment of the arbitrator.
Right. In fact, my lord, 11.6a deletion and notification will mean that this matter will completely go away from the courts and be relegated to institutions. That was the thinking of the high level committee. But my lord, as on today, 11.6a continues. The deletion has not been notified.
And if it is notified, then what will be the effect?
My lord, the change will be that really this jurisdiction of 11 will be taken away from all courts and vested in institutions which are, my lord, as it were, notified and, my lord, as per the Supreme Court or the High Court, will then, my lord, approve such an institution, and that institution, whatever, my lord, institution will be, will actually just make the appointment. That seems to be the trend which is now going, because, my lord, I want to say one very interesting thing which is not here, which is that there are 85 countries in which there is the model law. This Article 11 is there in 85 countries. My lord, there is something called case law on ancestral texts. I'm the one of the national correspondents. No other country in the world has any jurisprudence of any worth on Article 11, on Section 11. Yet, I am before a constitution bench, my lord. We were before 7 judges in SBP. Section 11 has been amended multiple times. My lord, why? My lord, I'll answer this question at the end as to why we are suffering from this Section 11 problem. My lord, there is
Judicial overreach.
No, it is not the court's fault. My lord. Every time we think it is judicial overreach. My lord, I'll answer the question now. In every other jurisdiction, there is a Section 16 appeal. There is an Article 16 appeal. In every other jurisdiction, there is a full Article 16 appeal. So all these questions go to the arbitrator. If the arbitrator gets it wrong, the court may or may not intervene in 16. But we have footballed it right to the beginning so that your lordships are bothered with Section 11 applications day in, day out. Long judgments are written, long debates are there, and my lord, we are before my lord. That was never the intention of Section 11. That was never the intention, and the statute also makes it clear that you are to confine, my lord, the word is confine. Nobody's seen the word confine. Confine to the existence, to the examination of the existence of the agreement. That's all. That's the Lakshman Rekha. Nothing more. In fact, my lord, I quoted Justice Korean in Duro Felguera, where he puts it in 2 lines, my lord. He puts it so beautifully. If your lordship sees page 2 of the note, after the amendment, all that the courts need to see is whether an arbitration agreement exists, nothing more, nothing less. My lord, I've quoted it, my lord, in the second page. Page 4, my lord. Page 4, my lord. I've quoted this passage. Your lordship just sees this passage. After the amendment, all that the courts need to see is whether an arbitration agreement exists, nothing more, nothing less. In the synopsis, page 4. Would your lordship want to see it from the judgment itself? The legislative policy and purpose is essentially to minimize the court's intervention at the stage of appointing the arbitrator. This intention, as incorporated in 11.6a, ought to be respected. Well, this is, according to us, the correct understanding of the legal position. As an 11 judge, you will look and see.
What would be the effect of this exercise? If 6 days notified,
Sorry, madam.
if it is notified, then what?
This exercise will then, my lord, be done by the institution.
No, no. What will be the effect of this exercise undertaken by us after 6 days notified?
My lord, the exercise undertaken by your lordships today
Yes.
will dispose of a very, very large number of, my lord, cases. There is resistance to this notification because there are no, my lord, institutions which the government is comfortable with giving this power.
Court or no, it understand the thing is, it's going to be agnostic, whether it is court or whether that body.
Right.
The same problem will remain.
Same problem with them. But there, my lord, there will be no problem because nobody will go to them, nobody will argue stamping, nobody will argue a court satisfaction.
Maybe.
They will appoint.
We don't know
But
what they will argue.
how do you know nobody will be
We
arguing?
can't be.
My lord, because we have some experience, my lord, of all these international institutions. They have some rules, my lord, which are framed like SIAC, LCI, etc., etc. They only look at whether there is an agreement, there is a clause.
You know, if we hold, just like the court, I mean, as far as the court is
Yes.
concerned, look at the question whether there is exists an arbitration agreement,
Right.
whether it is stamped, what is the effect of it not being stamped, will be looked into by the arbitrator.
Right.
Section 16.
Right.
Then the same principle will apply.
Same principle.
To
Same
the
principle.
body.
Same principle.
Will come of the delusion.
Practically, nobody is.
Practically, my lord, I must tell your lordship, nobody does it. Practically, I'm only, my lord, explaining, my lord, what practically happened. In fact, my lord, this appointment of arbitrator was never meant to be such a, my lord, big thing. After all, it only happens to fill a gap. Normally, you appoint by consent. It is only when there is no consent or some deadlock that the court is dragged in. So this was really a stopgap, my lord, to break the deadlock. So, my lord, our submission is, my lord, my submission is that, if your lordship just see page 4, as my lord Justice Ravi Kumar pointed out, the existence or validity of an arbitration agreement is not affected by the provisions of the Stamp Act. Non-payment of stamp duty will not invalidate the instrument because it is a curable defect. And my lord, the submission that I will advance is that 11.6a, my lord, is really a matter which is to be left to the arbitrator, and the arbitrator has the full power, my lord, under section 35 to impound, stamp, etc., etc. In fact, the expression used in the Stamp Act itself gives the arbitrator power to do so. My lord, I also submit that neither lay down the correct law, and then your lordships may, my lord, decide the question in a sense in a clean slate. My lord, with this background, would your lordships now look at the Stamp Act?
There's just one clarification we wanted to. We come to page 234 of your convenience compilation.
Please, my lord.
There, the judgment of Justice Ravindran in the SMST case,
Yes, my lord.
one example which he gives, or an instance which he gives, which is at para 15.
15, my lord.
15 of NN Global.
Correct.
Please read para 15 of 15 because they both are para 15.
Both are para 15.
So if you just read that portion, but where the contract is.
Instrument is voidable at the option of a party as under section 19. The invalidity that attaches itself to the main agreement may also attach itself to the arbitration agreement if the reasons which make the main agreement voidable exist in relation to the making of the arbitration agreement also. So, my lord, this is.
Just give that example. Just he deals with the example.
Yes, ma'am. For example, if a person is made to sign an agreement to sell his property under threat of physical harm or threat to life, and the said person repudiates the agreement on that ground, not only the agreement for sale, but any arbitration agreement thereon will not be binding. My lord, I assume this is correct. But then the only question arises whether this issue of, my lord, whether. Yes, that's really the question. Of course, my lord, in fact, 16 uses 3 words. It says existence, it says validity, and it says jurisdiction, which is wider than existence and validity. So, my lord, these are typically questions which will require evidence, whether he has been threatened with duress, etc. So, it will go to 16. There's no difficulty with this.
No, the point is that, in such a case, there is no question of, this duality of existence of two agreements within an agreement.
It is the same agreement.
It will be one brush will paint everything black.
My lord,
The whole thing will fall to the ground.
my lord, in fact, this competence also has its limits.
That's right.
There is a role for competence, my lord. In fact, there are some very interesting passages of Justice Thakkar in the dissent in SBP Patel. He was the single dissent. My lord, the idea is that there is a scope for competence. It is reflected in section 16. It is really only limited to give the arbitrator power to decide questions which go to his jurisdiction, and for that purpose, you may have two separate agreements. The question is, I don't know how far you can stretch that legal fiction. We'll come to, my lord, we'll come to section 16 and I'll address your lordships on competence also. But my lord, first, if your lordship sees the Stamp Act, well, nobody looks at the Stamp Act, my lord. Unfortunately, everybody looks at the Arbitration Act, and my lord, I confess I also fell into the same trap when I started. We all look at the arbitration law. So if you look, so your lordship looks at few provisions. I have summarized, my lord, my submission on Stamp Act in a few pages in the note. My lord, if your lordship just first see the provisions. Do we have you given a copy? So we've handed over copies of the stamp. Let me first see section 211.
Instrument.
Lordships have two subsection 11. Duly stamped as applied to an instrument. So one of the stamp goes with the instrument, means that the instrument bears an adhesive impress stamp not less than the proper amount. Such stamp has been affixed. So 211 is on duly stamped. Then 214. Instrument includes, there are A, B, and C, and C is, my lord, any other document mentioned in Schedule 1. Now, my lord, the way the Stamp Act works, your lordships will know, is that if it is entry 91 of list 1, then the central government, my lord, imposes the stamp. And if it is, my lord, entry 63 of list 2, my lord, all this is mentioned in the note, then it is either the state brings in an amendment, Schedule 1A, or in certain states like Maharashtra, etc., there is a separate Stamp Act. My lord, there are some minor variations in language, but according to me, my lord, it will not make any difference to the question of law which falls for your lordship's consideration. Now, my lord, your lordships have seen 211 and 214. Please see section 3. Now, this is a little important. Section 3, your lordships will see. Under the heading stamp duty, liability of instrument duty, subject to the provisions of this act and the exemptions contained in it, the following instruments shall be chargeable with duty. So, my lord, what is chargeable is the instrument and not the transaction. And, my lord, we have put in the note, my lord, a judgment of the Court of Appeal of Lord Esher. I'll just tender that, which has been followed with approval by the full bench of the Allahabad High Court. Justice Suleiman, as he then was, followed the judgment. The reason I'm emphasizing instrument, my lord, is because, my lord, there is a confusion between instrument, my lord, and the transaction. My lordship just sees this. This is 1889 23 QBD 579. But just to give the background as to what was there in the case, Lord, the entry in the schedule or in the Stamp Act was that the party was required to pay stamp on conveyance or transfer of sale, transfer or on sale of property. So what the parties did was, they did not enter into a conveyance or transfer sale. They merely entered into an agreement to sell. they did not further enter into the actual conveyance by which the property was to be sold. So the commissioner said, sorry, you should pay stamp duty on this. The Court of Appeal said, no, it is what is said in the entry and the instrument and not the underlying transaction, which may effectively be a transfer. So, my lord, I'll just read the head note and 2 paragraphs of this judgment. The head note says, schedule to the Stamp Act imposes ad valorem duty on every conveyance or transfer sale of any property. By section 70, terms conveyance or sale includes every instrument and then held, affirming the judgment of the Queen's Bench, an agreement for the sale of goodwill of business, effect which in equity as between the vendor and purchaser, make the purchaser the owner, which a court of equity decreed specific performs in event of vendor and fulfilled, was not within section 70, not liable to duty. This was the ratio of the judgment, but I am not on the ratio of the judgment. Please come to the passage which we rely on, which is at page 589. Should have 589. In this case, the Commissioner in Revenue decided ad valorem stamp ought to be attached to the instrument in question. Divisional Court overruled their decision. This appeal is brought by the Commissioner. Now, the first thing to be observed is when the legislature assumes to impose tax on a subject, must do so in clear and distinct terms. If the matter remains in doubt, subject to entitled judgment. Subject to that observation, the question is whether the instrument was laid before the Commissioner, conveyance on sale within the meaning of 70th Stamp Act. That section says term conveyance on sale, and the section is quoted. Now, this is the sentence that we rely on. This is 3-4 lines here. The first thing to be noticed is that the thing which is made liable to the duty is an instrument. If the contract of purchase and sale or a conveyance by way of purchase sale can be or is carried out without an instrument, the case is not within that section and no tax is imposed. It is not the transaction of purchase and sale which is struck at, it is the instrument whereby the purchase and sale are effected which is struck at. And if anyone can carry through a purchase and sale without an instrument, legislation could not have reached that transaction. So, my lord, the short point of this judgment is, and my lord, this is followed in that full bench of the Allahabad High Court. Short point is, Stamp Act hits at an instrument. That may be relevant for the argument of competence, etc. Stamp Act is not concerned with the transaction. If the instrument is there, it fits the schedule, you have to pay. So, this is one aspect which I thought required clarification. Now, my lord, so test 1 is instrument. Step 2 is it in the schedule? Now, my lord, here, unfortunately, there is appears to be an error in NN Global, because NN Global holds in 2 paragraphs that an arbitration agreement is not liable to stamp duty. And, my lord, the question which is framed for your lordship's reference also appears to carry that error. So, my lord, I just first want to show NN Global, 3 paragraphs where there is a problem, and then, my lord, show the schedule which shows that the agreement, my lord, is arbitration agreements are covered. There are judgments also, 100-year-old judgments, which say arbitration agreements, even, my lord, separately may require to be stamped, because after all, an arbitration agreement is also an agreement. There cannot be any dispute about the fact that it is an agreement. So all agreements required to be stamped.
Which are those provisions in the Stamp Act?
My lord, we've set it out in the note, my lord, Article 5.
Article 5.
Article 5.
Let us see that.
That, my lord, is, my lordship sees the...
because they were dealing with the Maharashtra Stamp Act.
Same article.
It's the same.
Same article.
No.
Article 5 is the same.
Article 5
is the same.
Indian Stamp Act, Article 5C is a residuary provision, whereas in Maharashtra it is 5, small h, capital B, if not otherwise provided, 100 rupees.
All acts, my lord, I have seen 7 or 8 acts, they all have this residuary provision. 5C in the Indian Stamp Act is reflected in...
Let us see that.
My lord, page 43 is where the schedule starts. And 5C is agreement, 44, my lord, agreement or memorandum of agreement if not otherwise provided for. So, my lord, the assumption in NN Global that an arbitration agreement, even a standalone arbitration agreement, is not liable to stamp duty may not strictly be correct. And to that extent, my lord, your lordships will have to. My lord, the three places where it is mentioned, I'll just show, my lord. Your lordship may just note para 20, 24 and 58 where the question is being formulated.
You have the Maharashtra Act, Stamp Act?
Yes, looks.
No, it's been filed by my friend.
Same, similar, it is similar?
It's a bit different. The residuary is the same.
Residuary is
Residuary is same. Instead of 8 annals as under the Indian Stamp Act, it is rupees 100.
Whatever
That
it
is,
is.
it's, in fact, your lordships may just see the convenience compilations, one filed by us, the Maharashtra Stamp Act.
That's 12 is good. 12 is good.
Your lordships may straight away come to page number 21, convenience compilation 1, filed by me. It is agreement or its records or memorandum of an agreement, and then H, B, if not otherwise provided for.
I've looked at 7 or 8 acts, all of them appear to have this residual clause.
So the basis for the reference order to find that it is not exigible to stamp duty is not
At all. That portion, my lord, is not correct. I'll just show that, my lord. If your lordship sees my compilation reference
We have
judgment.
seen that, we have seen that.
So 3 paragraphs, my lord. In fact, the court refers to Article 12 award, but misses this particular article.
Even in that, there's a factual error.
That's not the Maharashtra Act.
That is not the Maharashtra Stamp Act. It is the Indian
It's the Indian Stamp
Award, which is quoted as Maharashtra Stamp Act.
But my lord, they have not, they have this in 3 places, they proceed on this basis, which is why, my lord, in my note, which I had tendered before my lords, I had deleted 5 words. I had taken the liberty of deleting 5 words from the, my lord, reference order. The lordships may recast the reference and your lordship just see my note at page 5 for a moment. I had deliberately, my lord, I had said, my lord, those words may not strictly be appropriate, which is not chargeable to payment of stamp duty. So, my lord, the Stamp Act, your lordships have seen the provisions. Your lordships have seen section 3, instrument. Then, my lord, 5 and 6. My lord, 5 and 6, to answer Justice Bose's question, my lord, as to how valuation is to done, my lord. It is 5 and 6 which address, my lord,
5 and 6.
of the Stamp Act. Instruments relating to several distinct matters. Instrument comprising relating to several distinct matters chargeable with the aggregate amount. Actually, 6 would be more appropriate.
This court has discussed this. This court also dealing with
5 and 6. 5 and 6. So, my lord, then your lordships will see 3 or 4 provisions, which are the provisions of some debate, my lord, which are 33, 34, 35 onwards. That is chapter Roman 4. Which starts at page 25 of this scheme. 33, I will come back to, my lord, 33 and 35 later. But 33, my lord, says, every person having by law or consent of parties, which will include an arbitrator, authority to receive evidence, and every person in charge of a public office, except an office of police, before any instrument chargeable in his opinion or duty is produced, or comes in the performance and function, shall, if it appears to him that such instrument is not duly stamped, impound. This is the provision for impounding. And then thereafter, whatever happens. And then 35 is the provision, my lord, which is effectively the statutory bar, which is instruments not duly stamped, inadmissible in evidence, etc. instrument chargeable with duty shall be admitted in evidence for any purpose by any person having by law or consent of parties, authorities to receive evidence shall be acted upon, registered, authenticated, unless such instrument is duly stamped. So one of these two provisions, your lordships will have to construe at some point. I'm only flagging them now, my lord, because there will be some debate on this. Then, my lord, then 36 is important. If you have actually admitted it, then you cannot question it. 38 is the procedure for dealing with impounding, and my lord, 42 is endorsement. I have mentioned all those provisions, 40, 42, my lord.
The proviso in 35 also you can read.
35 proviso, my lord. Provided that any such instrument shall be admitted in evidence on payment of the duty with which the same is chargeable. Case instruments insufficiently stamped, the amount required to make up such duty, together with a penalty of 5 rupees or 10 times the amount of the proper duty, deficient portion thereof exceeds 5 rupees, sum equal to 10 times such a duty or portion. So, my lord, that 5A is there are some exceptions also, my lord, in 5BCD, but this A effectively, my lord, provides the procedure. You pay the amount, you pay the penalty, and you get it. So, my lord, this is so far as the provisions of the Stamp Act are concerned. Now, my lord, insofar as the Stamp Act is concerned, my lord, I have culled out a few judgments which throw, in my respectful submission, some light on this. Note, I'm at page 8 of my note at the moment. Pride of place, of course, is given to, my lord, our Supreme Court, then, my lord, the Privy Council, and then some High Court judgments, and then one judgment from one foreign jurisdiction, my lord, which one of my, my lord, juniors very, my lord, discovered, and I found it to be very, my lord, interesting and appropriate. But I'll come to that later. My lord, the first judgment that I would bring to your lordship's attention is this Hindustan Steel judgment. Lordship, take volume 3.
There is convenience compilation part 1.
Yes, Manoj, this is part 3, which is the Stamp Act. The first judgment in this compilation, judgment called Hindustan Steel versus Dilip Construction Company. Now, this was also an arbitration case. And Manoj, the facts in paragraph 1 have some relevance. I'll just place paragraph 1 now. Respondents entered into a contract with Hindustan Steel, raising, stacking, carting, and loading into wagons, limestones, Nandini mines, dispute which arose between the parties. Arbitrators differed. I'll skip to about the 6th or 7th line. One of the contention raised by the appellants was that the award was unstamped and on that account invalid, illegal, and liable to be set aside. Have your lordships got that sentence in the middle of the paragraph? Thereafter, my lord, the matter comes up, the district judge impounds it, duties to be paid, etc. It comes up to the Supreme Court. My lord, please see para 2. Urged by counsel for the appellants, an instrument which is not stamped as required by the Indian Stamp Act on the payment of stamp duty and penalty to be admitted in evidence but cannot be acted upon for the instrument, quote unquote, as quoted, my lord, by the dishonorable court, instrument has no existence in the eye of law. The argument was it had no existence in the eye of law. Then, my lord, the Supreme Court sets out various provisions. I have read all these provisions, so I'm not going to trouble your lordships with all these provisions. Please straight away, my lord, come to paragraphs 5 to 8. No, I'll just read para 7. Rather than the full portion, I'll just read para 7. The Stamp Act is a fiscal measure enacted to secure revenue for the state on certain classes of instruments. It is not enacted to arm a litigant with a weapon of technicality to meet the case of his opponent. Stringent provisions of the Act are conceived in the interest of the revenue. Once that object is secured according to law, the party staking his claim on the instrument will not be defeated on the ground of initial defect in the instrument. And then, my lord, the provision, the Act is analyzed, and the Supreme Court says that the document having now been stamped, it is valid, etc. The relevance of this is it explains really the scope of the Stamp Act. That the purpose of the Stamp Act is really to protect the revenue and not to give a weapon to a litigant. And once that aspect is protected, then the party staking the claim on the instrument will not really be. So, this is one step of the way. The paragraph 8 refers to a judgment of the Allahabad High Court, in fact, the minority view, which is not accepted by the Supreme Court. I put that in just for the sake of this was one view, this was the view which has been taken in Hindustan Steel.
But this is after impounding.
This is after impound. Yes, this is after impound. The Lordship is right. Now, my lord, I go one step further. So this is after impounding. You can cure the defect. Now, my lord, if your lordship goes one step further,
that proposition possibly
there cannot be any dispute. So, my lord, the other two judgments of the Privy Council and the Patna High Court, which I have noted in page 8, my lord, also effectively say this. So, my lord, I am not going to trouble your lordship. I mentioned the passage and the portion from the judgment. I am not going to waste your lordship's time unnecessarily on this aspect. My lord, the question is a little different. The question is, supposing there is a document, it is not stamped, it ought to be stamped, or it is inadequately stamped. What is the legal basis of that document? Is it
what is argued, sir?
Sorry,
11.6 in the application,
right?
Court is to see whether there is an arbitration agreement or not.
Right.
Now, normally that agreement is annexed.
Right.
Does it not assume the character of an evidence?
My lord, I will say this.
Because then it would become inadmissible and we look into it.
Yes, my lord. In fact, your lordship will have to read what you mean by the word existence, what do you mean by the word validity. All different expressions have been used in the Arbitration Act. Very interestingly, existence has been used somewhere, validity has been used somewhere, jurisdiction has been used differently somewhere, arbitrability has been used. I'll show that, my lord. So, my lord, because really a Section 11 court, my lord, in some senses is a court,
ministerial court anymore.
Is my lord,
is a mind applying court.
My lord, the question is, again, my lord, we should not fall into the question of judicial versus administrative. My lord, I would rephrase the question. I would say what is, and that is how the Law Commission says, what is the scope of inquiry of the 11 court? What is his scope, his or her scope? That's the expression, my lord, which is used.
Scope what is whether there is an arbitration agreement or not.
My lord, in fact, I will show, my lord, there is an emphasis on the word existence. The legislative history shows that the words used are, my lord, very interesting. Confine, first the word confine, namely, my lord, you are limited to the examination of the existence of an arbitration.
Yes. Now, where do I find that one? Where do I find that arbitration agreement?
My lord, in the document, no difficulty.
In the document.
My lord,
the document is produced as an annexure.
Right, my lord, but your lordships are not admitted
as an evidence.
Right, my lord, my lords are not admitting it into evidence in the way that you are required, my lord, under 33 or 35 to do.
Summary proceeding like in REIT.
Right, my lord.
All the annexures are also evidence.
my lord,
and they are affirmed on oath by the very.
no, let me, my lord, tackle that.
Anyway, you go on.
No,
in your
I understand. My lord, the question really is whether you can even look at that document, because by looking at it, you are admitting it into evidence. I will show, my lord, that there are different phrases which are used and different ways it has been understood. And the legislative history will show to my lords that what you are really required to look at, and that's also in Vidya Rolia, is that yes, you have to satisfy yourself that there is a concluded contract. You may have to satisfy yourself that there is consideration, some formal requirements you will have to satisfy yourself. But in the process of looking at that document, it will not be going to the next stage of admitting it formally into evidence and deciding on, my lord, the or even, my lord, acting upon it in that fashion. I'll show the, my lord, relevant. I'll show the history of it to satisfy your lordship, because, my lord, it all depends on how you read that phrase. Existence could be read widely, could be, my lord. It could be said that existence of an arbitration agreement may include whether accord and satisfaction was there or not, because an arbitration agreement ceased to exist because there may be subsequent accord and satisfaction, or agreement exists but limitation bars. This could be, my lord, existence could be wider. Not, I'll come to that. My lord, if I could just go back to the Stamp Act, and then I'll immediately, my lord, come back to that. So, my lord, one is what happens after impounding. That's my lord, unexceptional. What happens pre-impound? Supposing a document is not impounded, what is the value of that document? Is it waste paper? Is it relevant? Is it irrelevant? My lord, to answer that, my lord, we have carved out, my lord, we have mentioned 3 or 4 High Court judgments and one other judgment. I'll just place those judgments, my lord, as to where is the line which is drawn. So if your lordship comes to page 9, come to page 9 of the notes, and please come to Joyman Beva, which starts at page 31.
Page 31.
31. Well, the relevant portion I'm not reading the facts, but this was a document, which was not stamped, and it ought to have been stamped. Now, please come to page 33.
Just 1 minute. Yes.
33, somewhere in the third paragraph, in both the lower courts, documents exhibited and evidence marked as an exhibit. Lower appellate court dismissed the application on the ground that inasmuch as the contract of suretyship was not duly stamped, it was not valid as a contract. And not further held other things. So the lower appellate court dismissed the application because the document was not duly stamped. On further appeal to this court, the contention that the contract contained in the petition was rendered void because it was not duly stamped, was not persisted in. In my opinion, there is no substance in the contention. Failure to duly stamp a document which must needs be stamped by reason of the provisions of the Stamp Act does not affect the validity of any contract therein contained, but renders the document inadmissible in evidence. This is the line of distinction that we are seeking to draw. Assuming you are confronted with a document which is liable to be stamped, it is not admissible in evidence, but it doesn't mean that the contract, the contract ceases to be valid. So, that principle, there are a couple of other judgments which say that, if your lordships then see page 36. It's a little more elaborate. one portion of the judgment your lordships may ignore here. It is volume 3.
Conveyance completion part 3.
Lordships have it?
You got a stamp, I think. Stamp, I still want to say. Now you're going to. Yeah.
Now, the second judgment is at page 36. There are some interesting questions of etiquette and English bar that you should not raise such questions, my lord. That can be ignored for the purposes, my lord. That is no longer the practice, that you should not raise such a question because it is not appropriate to raise such a question. That portion of the judgment your lordships may not look at, but the reasoning on the substance is at page 39. At the top, Mr. Basu's first contention on behalf of Phulchand and Murlidhar, the document is not valid, not properly stamped. No substance in this contention. Then, my lord, section 35 is set up. Effect of the section is to make such an unstamped document inadmissible by evidence, unable to be acted on by person. It does not affect the validity of the document. There's a clear distinction to be drawn between invalidity and inadmissibility. Certain statutes and sections render documents invalid if they are not stamped. No section of the Indian Stamp Act has this effect, instant of a document being rendered invalid by the omission of stamp contained in the English Stamp Act. And my lord, he gives an example of the English Stamp. So, my lord, this is another judgment, and then there is a third very similar judgment by at page 43, my lord. This is by Justice Bijon Mukherjee, as he then was. And, my lord, the relevant portion is at page 47, where he summarizes it in one paragraph at paragraph 15. Your lordship, see paragraph 15. Page 46. Here the document could not be stamped because the gentleman died. So the document could not be stamped. And it was argued that now you can't do anything about it. The High Court said that failure to stamp a document has got to be stamped, does not affect the validity of the transaction, merely renders the document inadmissible. Got it stamped. Now, my lord, the most interesting and the last judgment in this section on Stamp Act, which I will show, my lord, is a judgment your lordships will see at page 103. I want to make some comments on this, my lord. It's a very interesting judgment. Please come to 103. Your lordship's got 103. My lord, this is a judgment delivered by a gentleman by the name of Gourab Patel. He was a Parsi judge who refused to take the oath of allegiance when General Zia-ul-Haq came into power and resigned. He would have been the Chief Justice, first minority Chief Justice of Pakistan. He also wrote the dissent in the Bhutto hanging case. So this is and he's a well-known jurist, and all the judgments he relies on in this one are all pre-independence and all Indian judgments. But the way he puts it is very interesting. So there are a number of, my lord, very interesting paragraphs in this. And I'll just place it just for your lordships to see what is said here. My lord, the issue here again arose out of an arbitration case. What had happened was a defense was taken that after the award was pronounced, a defense was taken that the arbitration is bad, the award has not been properly stamped. The agreement has not been properly stamped. So it is not admissible in evidence, it was not properly stamped, and therefore the award itself is null and void. And the question which was framed, your lordships will find, is at page 105 in the second paragraph at the end. I'll just read that. According learned judge dismiss every appellant filed petition leave the court admitted in order to consider court whether there could be any valid arbitration proceedings in the face of the agreement not being duly stamped in violation of 35 of the Stamp Act. So, my lord, this was not a case where the defect was cured. This is a case where the defect was not cured and yet the arbitration went on. Then, my lord, he sets out 35, and the passage which I'm relying on, my lord, is at page 1, effectively, my lord, pages 107 to 109. There are some very nice sentences, my lord, here. Bottom of page 107, after setting out all the provisions, my lord. There's a typographical error in the third paragraph. Your lordships may please correct that. The only other section, this is the third or fourth paragraph, the only other section which is relevant to this appeal is section, it should be 61. It should not be 66, it should be 61. Then the last paragraph, and now examine 35 in some detail. Prescribes no instrument not properly admitted for any purpose or shall be acted. Now, merely because an agreement instrument cannot be admitted in evidence on any purpose, as because it cannot be acted on the person specified, does not mean that such an instrument is invalid, not irrelevant. To observe, words which I have quoted have to be construed strictly because they are to be found in provision of penal nature. Therefore, it would be against all canons of construction to enlarge the meaning of these words so as to render invalid instruments which fall within the mischief of this section. This is the first thing he says. And then, my lord, he gives a number of examples. He says, after all, instruments which are not duly stamped are executed every day. But I venture to think that most persons who incur obligations under such instruments honor their liabilities under such instruments regardless of provision of 35. This is one thing he says. And if your lordships come to 108, this entire passage, my lord, is worth reading. I'm just picking out few sentences. 108, last sentence. These provisions, as well as other provisions in Chapter 4 of the said Act, such as Section 33, 38, 39, 40, can only lead to the conclusion object of the legislature in enacting the said Act was to protect public revenue and not to interfere with commercial life by invalidating instruments vital to the smooth flow of trade and commerce. And, my lord, at 109, he follows the various judgments, Calcutta High Court, English law, etc., etc. So, my lord, this judgment, I've given all the relevant paragraphs, my lord, in the note. I'm not going to read them out. But the language which has been used to explain 33, 35, 38, 39, Indian law, English law, and, my lord, ultimately he agrees with the view propounded by the Indian courts, and he overrules a judgment of the Lahore High Court post-independent. He says whatever law, my lord, was formulated by us is insofar as the section is concerned, is correct. So, my lord, all these cases establish one thing and one thing alone, that merely because a document is not stamped does not mean, my lord, that the transaction or the contract or the agreement becomes invalid as a matter of law. So, my lord, that is an important conclusion because that will have some relevance, my lord, later. Lord, you just see.
Mr. Banerji, in this case, how did they do? Because you said here the stamp was not collected.
Stamp was not collected, my lord.
So, how did they deal with that aspect? Because the others, they said that you should collect it.
Collect it. My lord, here what happened was at the award stage, my lord, it was raised. So, by that time, my lord, stamp had been paid on the award. The agreement was unstamped. So, in this stage, the award state had been reached. And your lordship is also aware of those provisions of 36, etc., that if a document is inadmissible and you don't raise the issue of stamp duty, then it is accepted. So, my lord, here there was, on that principle,
Section 36 was not resorted to here.
36 was not resorted to here, my lord, but this was at the award stage. And it was in fact not even at the award stage, it was at the execution stage. So, in the execution, he said it is void. So, the court said it is not void. So, that is, perhaps, my lord, they could have collected the revenue, but it was.
That's not appearing.
It was not. So, my lord, these judgments, so far as the Stamp Act judgments are there, my lord, I have just summarized my submissions, my lord, in 4 or 5 points in page 11.
12.
That's the second subject. So, my lords, all we are establishing with reference to standard, simply that it cannot be said that that document is a waste paper. It is invalid. Yes, it is inadmissible in law. Not certainly that's a matter of admissibility. That may not be a matter of jurisdiction. Your lordships know the distinction between jurisdiction. So, my lord, with this background, then, my lord, I come to answer, my lord, the question which is put. And for that, my lord, I would first ask your lordships to look at the Arbitration Act. Well, this Arbitration Act has undergone a lot of changes. In fact, my lords, I've had the privilege of being associated with it at various stages when the various changes have been made. And unfortunately, my lord, when we brought in this act in 96, it was brought in a bit of a hurry. And some safeguards in the act, even for international commercial arbitration, were deleted. That's a matter for another day. And thereafter, my lord, there has been one major change in 2015. There has been another change in 2019. There is another change in 21, which is not really relevant. But the two major amendments are the 2015 amendment and the 2019 amendment. So, in fact, my lord, the way it is put in Justice Khanna's judgment in Vidya Drolia is that there are 4 periods. So, he says the first period is the SBP period, which concludes with the judgment in SBP. The second period is post that pre-19. Third period is 2015, 2019, and fourth period is 19 onwards, which has not yet happened. So we are, my lord, in that 2015, 2019 period. So, my lord, first, if your lordship just see the act as it stands today with all the amendments. I'll show all the sections in seriatim. And your lordships may keep in mind that it is not only NN Global and Garwade that is in reference. There are a couple of paragraphs of Vidya Drolia which are also, unfortunately, my lord, tied into this. So that also your lordships may have to look at Vidya Drolia with some care. First, if your lordship sees, first please mark section 2, subsection 3. Your lordships have 2.3. 2.3 I am only mentioning because it has some relevance in the Vidya Drolia matter. This part shall not affect any other law for the time in force, by virtue of which certain disputes may not be submitted to arbitration. My lord, there are certain classes and categories of disputes like rent act, like family law, divorce, marriage, crime, etc., which are not capable of going to arbitration. You cannot agree to it. As a matter of policy, you cannot agree to a rent act matter going to arbitration.
Essentially, title or status.
Title or status, my lord. There may be. So, my lord, there may be many such cases, but it is, I would say, a way of putting it, my lord, is this concerns subject matter arbitrability. A particular subject matter cannot be arbitrated, whether it is consumer disputes or ABC. It concerns subject matter arbitrability. For instance, my lord, in Vidya Drolia, the issue was whether landlord-tenant dispute can be arbitrated. Rent act dispute cannot be arbitrated. The question was whether landlord-tenant disputes other than rent act disputes could be arbitrated. The court said yes. But, my lord, it was the subject matter which was in question. So that's why I'm showing 2.3. Then your lordships will see a very, very important provision, 5. Note 5 is at the heart of this legislation. Use that. No, that 5. Note 5 is taken from Article 5 of the Model Law. this will have some bearing on, my lord, the jurisdiction of the 11th judge. Notwithstanding anything contained in any other law for the time being enforced, matters governed by this part, no judicial authority shall intervene except as provided in this part. So, my lord, the purpose of this is to reduce and minimize judicial interference in, I wouldn't, my lord, I think interference maybe is a very harsh word, intervention. The word used is intervention.
Refusal to exercise power under section 11 on the basis of.
No, I'm saying,
Otherwise, yes.
Otherwise, yes. Otherwise, yes. It is one factor that your lordships will consider, that the purpose is minimal judicial intervention. 5 reflects that purpose generally. My lord, 11 will have to be read along with 5. Had 5 not been there, then, my lord, 11 may have been read more widely, perhaps. So, my lord, it has an impact. There is a commentary on Article 5. Well, this is I'm sorry I could not put it in the compilation. My lord. This is one of the best known, my lord, texts which explains the model law. And Article 5 pages are just taken out.
Section 5 is equivalent to Article 5.
Is equivalent. My lord, here every section is by and large equivalent to every article. That's the way we have copied it. My lord. Section 34 is Article 34. Section 9 is Article 9. Section 11 is Article 11. Section 8 is Article 8. By and large, my lord, there is great degree of similarity. So that's the basis. Article 5 states a simple but very important principle. Its purpose is to oblige the draftsman of the law state any instances in which court control is envisioned in order to increase certainty for parties and further cause of uniformity. As noted by the Secretariat, the effect of the provision is to exclude any general or residual powers given to the court of the enacting state in statutes other than the model law. Lord, there are other judgments of this court, for instance, in Kandla, which suggests that Arbitration Act is a self-contained court. That judgment I'll also mention. So the purpose of introducing Article 5 was that you did not want to leave any general or residual powers outside this statute to the state court. And my lord, that's why 5 is prefaced by notwithstanding anything contained in any other law for the time being enforced, which presumably may also include, my lord, the Stamp Act. My lord, 5 is relevant for that purpose. Then your lordships will see 8. I'll come back to 8, my lord, or your lordship may see 8 now.
No, you are saying might exclude Stamp Act altogether, including the requirement of paying the duty.
My lord, I am not saying, I am not going to that extreme. I am saying, my lord, the Stamp Act will operate only at a later stage, not at the 11th stage. I am not saying, my lord, the Stamp Act is completely excluded. Certainly, my lord, the revenue of the state will have to be protected. There's no dispute about that.
Which
When
you come to section 7.
Section 7, agreement.
You were going to 8, we thought.
7, your lordship is right. 7 is important.
7 is important.
7 is. My lord, 5 is extent of judicial. My lord, the idea is not to bring in through a side door in 5 other additional extra requirements. So that's the only, my lord, seems to be the purpose of 5, that it's a limiting factor. That's all I'm saying. I'm not saying that you completely, my lord, exclude anything. 7 is arbitration agreement. In this part, arbitration agreement means an agreement by the parties to submit to arbitration all or certain disputes which have risen or may arise between them in respect of a defined legal relationship, whether contractual or not. Now, this language is taken both from the New York Convention and from the model law. This is a cut, copy and paste of this portion. Most of it, my lord, is Article 2.2 of the New York Convention. An arbitration agreement may be in the form of an arbitration clause in a contract or in the form of a separate agreement. This is also well said. Arbitration agreement shall be in writing. This is an additional
Can we read 4B?
4B. 4B is an exchange of letters, telexes, telegrams, or other means of telecommunication, including communication through electronic means which provide a record of the agreement. So you can have an arbitration agreement which is consummated in more than one document. So you can have two documents.
If that applies, you just recall you referred to Article 5C of the Stamp Act.
Yes, Manoj.
Say that an agreement, an arbitration agreement, should also be stamped.
Should also be stamped.
So how would you apply it in a situation where the arbitration agreement
is in two documents, Manoj?
It's in maybe two or more documents.
Manoj, I would say
it says exchange of letters, communication through electronic means.
Right. So, Manoj,
which provides a record of the agreement.
Short answer, Manoj. If there is no instrument, there is no tax. Yeah. So, Manoj, if there is no instrument, Manoj, there has to be an instrument.
Exactly.
So if there is no instrument, Manoj, then there is no question of any stamp act, Manoj. So
why these 2-3 collection of letters or
may become one or may become one instrument.
It does say which provide a record of the agreement.
Which provide a record of the agreement.
You see the whole of it because
right.
it may have some
bearing, no?
Exchange of letters, telegrams, other means.
Which provide a record of. So I send a letter suggesting an arbitration clause. Somebody else says, I agree.
So, Lord, would that be an agreement, an instrument?
Lord, whether it would be an instrument or not would have to be seen, Lord, under the
240.
I'm obliged, Lord. 214 would
whether
be.
It would be an instrument within the meaning of 215.
My Lord Justice Ravi Kumar is right, Lord. 214 is every document, whether it will fall within this, Lord, will have to be.
We'll have to see that.
We'll have to see. We'll have to see that. My Lord is.
We'll have to.
I'll come back on this one. Whether it falls within 214, what happens if there are two documents which together form an arbitration agreement? How will 214 apply in such
more? Because you could have 2, 3, 4 more parties.
We could have correspondence going on.
Correspondence, you don't have to limit it to 2. You could have any number.
Because Manoj, this says every document by which the right is purported to be created, transferred.
When we saw it, we just wanted to point it out.
We says a document electronic or otherwise.
Created for a transaction in a that is stock exchange and deposit.
Any other document mentioned in it?
Which would be agreement, Manoj.
But the duty value is still the same, 8 annas.
Duty, Manoj, in this case will be.
We are inquiring.
Duty is, I think, 100 rupees in most places.
Okay.
100 rupees. 8 annas is, Manoj,
amended schedule.
100 rupees.
There is a section 77A in the Indian Stamp Act, which has given the conversion. What is anna? 4 anna is 25 paisa, 55.
Yes.
16 anna is 20. The Indian Stamp Act.
Most of us would recall.
8 annas is
basic.
8 annas is 50 paise. 16 annas.
To answer your Lordship's query, the Indian Stamp Act has section 35. If it is in letters, then what? Okay. The answer is it's in the proviso. 3. Where a contract or agreement of any kind is effected by correspondence consisting of 2 or more letters, and any one of the letters bears the proper stamp, the contract or the agreement shall be deemed to be duly stamped.
So therefore, even in such a case, it has to be stamped.
Even in that.
Which section did you?
35 proviso C.
Section 35.
Therefore,
Proviso
it have to be stamped.
Provided that C.
Of letters. So it would be an agreement.
It is an agreement, Manoj. There is no dispute.
So it would be an agreement.
In writing.
In writing, and therefore it would be an instrument. We just want
to. Section 214 defines the word instrument very largely.
Which includes agreement. Which
includes every document.
Absolutely. Includes
every document.
Which gives rise to, Manoj, any rights or liabilities.
If it's to be in writing, it will be a document.
It has to be a document. 7.3.
Otherwise, it cannot be.
7.3.
In fact, there are some very interesting developments there that now writing will, of course, include, Manoj, emails, electronic.
That is included here.
That is now included.
That they've included.
That, Manoj, they've now included in 2016. They've included it now. Manoj, that is 7. Then your lordships come to 8.
8.
8. Power to refer parties to an arbitration where there is an arbitration agreement. Judicial authority before whom an action is brought in a matter which is subject matter of an arbitration agreement shall refer party to the arbitration agreement. Any person claiming through or under him applies not later than the date of submitting first statement. Notwithstanding, Mullah, this is now new. Notwithstanding any judgment, decree, or order of the Supreme Court or any court, refer the parties to arbitration, and this is the relevant phrase, Mullah, unless it finds that prima facie no valid arbitration agreement exists. So the test in 8 is of validity. How this has come to be, Mullah, I will show from the
I
history.
think Vijay Dhodia has equated both.
Has equated both. Mullah. That also has to be seen as to how much your lordships wish to equate both or not, or to what extent it is to be equated. That's another. Mullah, in fact, there are 2 judgments in Vidya Dholia. There on some portion there appears to be some degree of inconsistency between the 2 judgments. Those I have also mentioned. Mullah. There are some issues where something is said in the first, something is said in the second. Normally, my lord, we don't look at all the judgments as lawyers, but once one has to assist your lordship, both judgments have their own nuances. We'll just point it out. My lord, if we then could come to 11. My lord, what is interesting about 11 is if you want to show 11 from, well, unfortunately, the book shows 11 as if 6A has already been deleted, but it has not. So that problem is
Notified.
It has not been notified. Your lordship is right. It has not been notified. So today, it's there in the footnote. One thing I want to show, not before one reads 11, is that 11 now uses the word High Court or Supreme Court. Earlier to use Chief Justice or designated judge, now it uses High Court, Supreme Court. But my lord, the High Court and Supreme Court are not the court mentioned in section 2. 2(1)(e) is different. High Court and Supreme Court is differently treated, my lord, in section 11. High Court or Supreme Court is not the 2(1)(e) court. It may not make any difference here, but it is certainly there because the court, 2(1)(e) court is usually the court of the district court or the high court, which has the subject matter, the jurisdiction, which has no original site. But here, my lord, specifically, court has not been used. The phrase has used either high court or Supreme Court. For instance, my lord, your lordships always have the situation that under section 11, there is no appeal. So it is always SLP. Your lordships are flooded with section 11 SLP. Because the role here was not to be, my lord, as we understood it. May I now read, my lord, 11(6)(a). 11(6)(a) is the bottom of the page. The Supreme Court, or as the case may be the High Court, while considering any application under subsection 4, 5 or 6, shall, notwithstanding any judgment, decree or order of any court, confine to the examination of the existence of an arbitration agreement. This is the language.
Slightly different from 8.
Different from 8. 8 says validity. This now says
prima
facie validity. This now says confined to the examination of the existence of the. Each section has a different phrase, and somewhere there is a reason for that. So, my lord, I have a number of. Then your lordship will also see 11(6)(b), which is the delegation. There's that one. 11(6)(b) is still a designation of any person or institution by the Supreme Court. Case may be the High Court for the purpose of section. Shall not be regarded as a delegation of judicial power by the Supreme Court, High Court. This is still there. This is so. Supposing now this is notified, or even if it is not otherwise notified, the appointment can be made by any ABC, ICA.
What is the reason for it not being notified?
My lord, I think possibly the government will give an appropriate answer. My lord, the reason may be that this was part of that high-level committee Justice Sri Krishna report. And a number of recommendations were made, including the Arbitration Standards Council of India. There was some resistance to that, but now, my lord, all that has been ironed out. And I believe Justice Hemant Gupta has been appointed to this body, and they have to actually accredit institutions.
That's right.
So until and unless there is a body which actually says institution A is appropriate, institution B is good, institution C is bad, maybe they are waiting to.
The number of high courts, I think, section 11 applications are kept pending. And this is what I get told.
Oh Lord, I have recently appeared in a case where a section 11 application of Jammu and Kashmir High Court has been pending for the last 11 years.
11 years.
11 years, despite 2 orders of this court to dispose it of. Oh Lord, it's an issue. Section 11 pendency earlier.
If it had been a suit, it would have been over.
At least it would have started. I don't know whether it would have been over. At least appointment is the first step.
Absolutely.
I think, we don't perceive the way this act works. The theory is that arbitration tribunal has the first bite of the cherry, but the first look. But the last look is always with the court. It is not that the court is being excluded, Manoj. There's a very nice passage of Justice Thakkar, paragraph 96 of the dissent, where he explains it and he calls it chronological priority. You first go to the tribunal, let them look at it. They have the benefit A of time, which the court doesn't have, B, my lord, of evidence, which again, my lord, puts pressure on the court. Let them take a call. Nobody is saying that because the arbitrator has decided I have jurisdiction, that's it. Then there is always court control. Look at the stamping situation, my lord. Today a section 11 judge has to decide on stamping. Let's take a practical example. He will say that this is duly stamped. He will say, no, this is inadequately stamped. Either you decide it yourself, you may get it wrong. In the present case, my lord, there is a dispute as to the quantification of the stamping. They say, no, it was just an agreement, but I have coughed up 8 lakhs anyway to get the matter going. So, my lord, if you push these disputes to the section 11 judge and you expand his jurisdiction, he is already overburdened. My lord, the entire purpose of arbitration is to take the dispute out of the system and settle it somewhere else. It is not that the court is losing, my lord, its supervisory jurisdiction. Supposing section 16 he holds, no, it's adequately stamped. You challenge in 34. You say that document is inadmissible. How dare you act on it? Have it set aside. Or you have misconducted yourself because you did not impound the document. You should have protected public revenue.
What if it is not stamped at all? All disputes where it is insufficiently stamped.
That's, well, Lord, if it is not stamped at all, what will happen? The day the document arrives, my lord, I also said the day the document arrives, my lord, I will then have to take a call. Either I will impound it, I may decide it myself, my lord, I will be in a better position to decide. I'll have the, my lord, benefit of the arguments of both, or I can send it to the collector. In the meanwhile, pleadings can be completed. 6 months is saved. If you do the same thing before a high court judge, my lord, practically, my lord, I'm saying, the next date is 6 months. The next date after that is 6 months. The 1113 says, my lord, I almost, my lord, I started laughing when I read it. It says application under this section shall be disposed of within 30 days. My lord, I asked myself, which application?
Arbitration is to be concluded in 18 months.
In 18, my lord, that is possible. That is still happening.
Unless you appoint the arbitrator, how will it proceed?
Yes, yes, ma'am. But 30 days.
Is not registered.
No, that is not.
No, but if my complaint is not registered,
You can't
in
proceed.
the first instance, what to say of the conclusion?
They have amended it. 18 months is from.
That's correct.
From pleadings.
The legislature thought that it must be
to
completed
start,
in
man.
months to start with.
My lord, the whole, and that, my lord, in fact, that is why in no other country of the world In no other country do we have this Section 11 problem.
That's one thing.
I found one judgment, my lord, from Bermuda of 2006 and one judgment from Hong Kong of 2008. That's all.
Only one thing. This is a additional window available as a mechanism for adjudication of the disputes expeditiously.
Right.
Arbitration.
Yes.
The law framers thought at given time that the regular mechanism available will take longer time.
Yes.
And commercial disputes could not be decided in the time framework. So let us have a different window.
Correct.
Our request to you is, please, I mean, if you go on the theory of unstamped, not sufficiently stamped, insufficiently stamped, to my understanding, any agreement or a document which you call the legal term, which creates rights or liabilities over the parties to the commercial agreement, fairly good, stamped, because it has to be placed as a document and to be exhibited at the stage of adjudication. This is in reference to an arbitration but in adjudication. The parties are not on the loggers for adjudication. So on. We only coming forward to have the arbitration of the dispute.
Right. But
This
is
is
not
not a
substantive rights and liabilities.
Yes.
It's just an arbitration.
This is not a dispute. This term of arbitration is only coming both the parties to a common stand that adjudication may take place in reference to the disputes in question. So our question to you is, as you said, it has to be stamped. What I feel is,
it has
look into it.
It has to be stamped,
It is in
but
reference
not by the court. My lord, it has to be stamped when the substantive disputes come before the arbitrator, then it has to be stamped. Because once it comes to the arbitrator, my lord, he can't get out of it. It will have to be stamped. Because of the language of 35, which covers a person appointed by consent also.
So ultimately, it will really boil down to one thing.
Yes, ma'am.
In the Section 11 application, when the agreement is produced, and the court takes a look at it and finds the existence of the agreement,
Right.
whether it amounts to attracting Section 35, the bar under Section 35,
Or not.
or not.
Right. That's it.
That is the only thing.
That, according to me, no, my lord, because 35 bar is only qua admissibility.
Admissibility as evidence.
And evidence. Admissibility of a document. It shall not be admissible
not
in evidence.
attracted by itself, it doesn't go to the validity of the agreement.
Right. So, my lord, if
And it is curable.
and is curable. So, my lord, existence has to be read. I would respectfully submit. My lord, existence can be read like this. It can be read like this.
That's right.
You can read existence in whichever way you want. But the section uses existence. Section 8 uses validity. Section 16 uses existence, validity, jurisdiction. Section 45 uses null and void, inoperative, incapable of being performed. It's a different test. That's a wider test. So, my lord,
So what you're going to say is, apparently, from what you're saying, an unstamped instrument is not void.
It's not void.
It is enforceable.
Right, my lord. Subject to admissibility.
It is not voidable as other instruments, agreements are not voidable in the sense.
It's not voidable.
Merely because it is unstamped.
It's not voidable. No, it's a valid document.
All that it suffers from is a curable affliction.
That's right.
Namely that it is not either
Sufficiently stamped or stamped at all.
Insufficiently stamped.
And that is a problem, a headache for the gentleman down the line. Please do not invite this problem on yourselves as the court.
And therefore, neither because the fact that it is not stamped nor insufficiently stamped will detract from it existing.
From its existence, and please appoint the arbitrator and he decides on the stamp.
It is not ab initio void. You cannot say it does not exist.
That's the argument. That's the actual, and therefore, my lord, 33. How do I get out of, my lord, 33 and 35? My lord, 33 requires me as the judge. My lord, I'm for a moment, my lord, pushing myself up and elevating myself up to a high court judge, my lord.
Can be in moot court.
Sorry, my lord.
Can be in moot court.
Include court, my lord. So, my lord, so supposing the court looks at this document and finds the existence of an agreement, I appoint, my lord,
No,
someone.
when court looks at this document,
Right.
to the court, what is the character of this document?
My lord, the court has to satisfy itself.
No, the moment, everything we can't look at.
Right, my lord. So what is, my lord, what is the character of the, may I phrase it differently? What is the scope of my inquiry? The court's inquiry. What is the scope of its inquiry? Does the scope of the inquiry, my lord, I am suggesting that the legislature has deliberately put a limit to the amount that that the court can examine.
So that will again take us back to the scope of the proceeding under section 11.
Right.
As to whether it involves letting in the arbitration agreement.
Right, my lord.
Into evidence.
Yes, your lordship is right.
If it does not involve, taking the arbitration agreement into evidence, but it only involves looking at it as to whether it really exists.
That's right. I will put it in a different way. That is one way of looking at it. Please see 33. What is the scope? What is the judge supposed to do under 33? He is to examine whether it is properly stamped on. I am suggesting, before you get to 35, you clear the hurdle of 33. 33 is one side of the coin, 35 is the other side of the coin. 33 is the judge, the section 11 judge gets the document. Normally, absent 11.6a, he is to examine this document to see whether it is stamped or unstamped. That's one. I am saying that in view of the language of 11.6, this part of the scope of inquiry is not required to be done by him. If 33 does not engage, my lord, 35 also does not engage, because 35 is the same thing you have to do in 33 and 35, namely satisfy yourself as to whether XYZ document is stamped or not stamped. So, my lord, that inquiry is not to be done by him.
What is the position under the 1940 Act?
My lord, under the 1940 Act, my lord,
there also, you would have had this.
My lord, you, there was no, my lord, there you would have to file the agreement in court. You would have to file the agreement in court.
So there also.
Section 20, it was in
Yes,
form of-
section 20 you have to file, and my lord, you would have to judicially apply your mind and then decide which disputes are to be referred.
So,
And
other decisions.
my lord, there are decisions under section 20. I can come back to that. My lord, section 20, in any event, my lord, under, I could find a couple of judgments, old judgments, which say that under the old act, my lord, the agreement had to be stamped. So, my lord, that was the procedure there. There is one very two-page 1800 Calcutta judgment, which is there. But there, my lord, the process was different. The court would define the scope of the reference. The court would identify the issues to be referred. My lord, that model is gone. Now we are on a, my lord,
No, we are only on that other limited
limit. I'll have
the
a
purpose of.
So, your lordships were looking at.
Mr. Banerji,
Yes.
would you be correct in our understanding that at the stage of exercising jurisdiction under section 11,
Correct.
an unstamped document may have its own consequence, may not be admissible in evidence,
Right.
but it can certainly not impair the triggering of the process of arbitration.
Yes, because, my lord, it exists as a matter of law.
That's
It
right. So,
exists. It is
so
not, my lord, a
judge is not
void.
going to have such a wide-ranging thing, but the trigger can definitely.
The trigger can go. My lord, let me be, my lord, absolutely frank. There it is, your lordship can take both views. It is eminently arguable the other way, my lord. I had great difficulty coming one way or the other. But if your lordship sees the evolution of 11.6 and 11.6a, it was never the intention to increase the scope of inquiry of an 11 judge, because effectively, my lord, an 11 judge, though we would not like to say it, is effectively, my lord, substituting for an institution. He is really a stop.
You can do the research work. This 6A of section 11 earlier came to this court. I am the author of that judgment. It arising from an insurance.
Yes, my lord. Anti-cards.
then Justice Rohinton
Overruled it.
bench,
Overruled it.
he again defined 6A.
Right.
My view was that as long as the judicial intervention is there,
Right.
some judicial discretion has to be left. You
Right.
can't put it into a
That
state
was
act.
anti-cards. Your lordship is right. That was that has
Very
been
important here is that the Rohinton's judgment
Mayavati trading. It's in the compilation.
is in compilation.
It's in the compilation.
And I think 6A has been elaborately put into
6 days were not discussed in Vidya Drolia in great detail. I'll show you, your lordship, that also.
That is also 3 judges.
That is 3 judges. Mayavati trading is 3 judges. I'm relying on Mayavati trading one.
Rohinton is the author of that judgment.
Yes, one paragraph. I will show of that also. That also is there in the note and the compilation. That's there. So, my lord,
So Banerji, 6A has already been interpreted by this court
sorry,
in totality. What is the scope and ambit of section 6A of section 11?
11.6.
What is stamped or unstamped?
my lord, 11.6a has been looked at in some detail in Vidya Drolia in the context of, my lord,
Document is not probably stamped.
no, in the context of subject matter arbitrability. In that process, my lord, 2 paragraphs of Vidya Drolia, Justice Khanna appears to have followed Garwari.
Earlier,
And that earlier SMS.
SMS,
My lord, SMS actually,
SMC.
SMS, my lord, frankly, SMS is so far in the past and it is pre to 2015, my lord. Whether your lordships will want to go into it as to whether it is, though the 3 judges overruled it, my lord, specifically, whether your lordships are required to go into it or not is a debatable proposition, because now post 2015, my lord, really the issue is.
So SMC took the view that for the purpose of section 35, separate instrument, though it may be, cannot be used for any purpose.
Any purpose whatsoever.
Contrast to the section 49 of the registration.
Fine.
That is how it went.
Well, there was a difference in unregistered document and then unstamped document. That's 49 provided.
Exactly. Any purpose, collateral purpose.
Collateral purpose. But my lord, that was at a time, please understand, my lord, SMS was at a time pre-2015 governed by SBP.
That's right, that's right.
My lord, we are still in the SBP mindset. Unfortunately, my lord,
6A has come up.
though 6A has come, we are in the SBP mindset. My lord, I argued SBP on the losing side, my lord, and I cannot conceive of more hostile bench. Justice Thakkar in the entire 7 judges, my lord, hearing did not say a single word in support, my lord. And I was much younger, my lord. The judges essentially told me that why are you insisting on a narrow interpretation of section 11? It will mean more work for you. You can argue your section 11 here and you can argue it before the arbitration there. So, my lord, anyway, one has some feelings. That's of course history, my lord. But still SBP is being followed in some of these judgments. And that is a problem because 11.6a specifically was brought in to
tide over
SBP. Despite it, Justice Khanna has cited SBP. Justice Nariman has cited SBP in Garware. There are some areas your lordships will have to, my lord, iron out the creases. Though the issue appears to be very narrow, but essentially, my lord, the issue is what would you want? What would you, the Constitution Bench, want an 11.6 judge to do? So all the High Court judges are waiting, my lord, as to how to deal with it. So it is not only stamping, my lord. It is primarily stamping, but it is not only stamping.
It is an approach.
It is an approach. So that is a question. My lord, one last section I want to show. So, my lord, 5 points on section 11. There is a non-obstante clause.
See, there may be certain instruments which may not be required to be stamped.
Yes, my lord.
37 section, the scope of provision under section 61.
Correct.
There, the question is whether it is duly stamped or not required to be stamped.
At all.
That also is a question.
That's also a question.
61 says
61.
duly stamped or not required.
Required.
Just give the evidence that
61. Provision.
Provision, but this description not
Discuss.
whether that particular instrument is required to be stamped.
Correct, correct.
If it is not required to be stamped, then there is a question of not duly stamped. There is no necessity at all.
Maybe that is going to be the picture. Whether it is being when section
We would submit it is not evidence
That is-
being admitted at the stage. Well, not 11 is, well, not, I would put it in this extreme fashion. 11 is not a normal court. 11 is not your lordship sitting in their normal jurisdiction deciding issues. That's not the scope of an 11.6 application. Though now long judgments are, that was never the intention. I'll show the intention.
But now some adjudicatory function.
Now it is, my lord, that is the question as to where to strike the balance. Moment
As it is.
As it is. The moment your lordship increase the adjudicatory functions, the consequence is that arbitration grinds to a halt on day one. Because courts are inevitably under pressure. 11 applications, I'm not saying extreme cases like J and K, but the reality is, my lord, moment one has to adjudicate, one has to find the time, one has to devote the resources, and, my lord, prioritize. Why should commercial matters be prioritized, for instance, my lord, over criminal matters? May not be, so that it is pushed to the back. But then the entire edifice falls. So, my lord, it has to be looked at from a broader perspective. My lord, I am not, fortunately in this case, I am not on that side or on this side. My lord. The lordships will look at it from a, my lord, from the perspective.
not lose the case.
So I
That's great advantage.
great advantage. My lord. So it's a very liberating, my lord, experience not to have to commit to a particular position. So, my lord, just to, my lord, summarize 11 in 5. There's a non-obstante clause. Its scope is narrower than the recommendation even of the Law Commission. My lord, it removes SBP, lock, stock and barrel. My lord, the language your lordship has seen.
Perhaps even narrower than 8.
It is narrower than 8. In fact, that's another issue as to whether, my lord, whether you can equate 8 and 11. So actually it is narrower than 8, my lord. 8, my lord, I must confess, I am a little less, my lord, gung-ho about 8. But certainly, my lord, 11, I feel that this is a matter which certainly courts should not be, my lord, burdened with. So, my lord, 11 is narrow. It is a amendment which has been made. And, my lord,
Continue tomorrow.
please.
How much time is supposed to be?
My lord, I have got through half my note. I try my best.
You can't take a middle path. You take either this way or that way, which according
My
to
lord, it will take a little bit of time. My lord, it will take.
Amicus can't have a middle path.
Well, it will take a little bit of time. My lord.
My lord, this will also have an impact on the section 9 point, my lord.
Right.
My lord talked about the approach.
This is the one you said 2.
No, but one thing is very clear, compared to what you argue.
In the morning.
Yes, yes. It will continue in the morning.
Section 11 is given an interpretation, an adjudication. Then the very purpose is frustrated.
But my lord, what the impact will be on section 9 also, my lord, is something that we would want the honorable court to see.
That's not on reference, I think that's it.
That's right.
Deep you. Chal. 30, madam, I can't go in.